Donald Trump created something called the Board of Peace. He named himself chairman for life. Foreign governments are pouring billions into it. Congress never voted a dollar for it. Nobody knows who controls the money. Nobody knows where the bank accounts are. And the whole thing hasn't even been legally formed yet. But somehow, the director of the United States Patent and Trademark Office personally filed trademark applications to protect it, not on behalf of a real company, not on behalf of a registered entity, on behalf of something that doesn't technically exist. And then, this is the part that should make your jaw drop, he petitioned his own office to waive the filing fee. His office approved it the very next day. He filed the paperwork, he waived his own fee, and he listed himself as the owner of a trademark for an organization he says he doesn't own, and that hasn't been legally created. Jamie Raskin saw all of this, and he brought receipts straight to the hearing room. What you're about to watch is Raskin methodically cornering USPTO Director John Squires, asking the simplest possible questions. Who asked you to do this? In what capacity were you acting? Where's your legal authority? And watching Squires twist himself into knots, trying to explain why the country's trademark office became Donald Trump's personal brand protection service. Watch this hearing, and I'll break down why it's so much worse than it looks.
The committee has read all 2,800 and can opine on what he saw as the ratio. Recognize the gentleman from Maryland.
Mr. Chairman, thank you. Director Squires, how did you come to file those trademark applications for the Board of Peace?
Thank you for the question, Congressman. We came to file, I had them filed in response to a immediate cyber squatting land grab of the domain name. And for those who are unaware of the term cyber squatting, it's like identity theft.
So were you acting as a lawyer for the Board of Peace at that point?
No.
So in what capacity were you acting?
Well, the Board of Peace, this is exactly the issue, and I'm glad to have the opportunity to explain it
Please.
and respond to your letter. The Board of Peace has not yet been formed as an international organization. And the cyber squatters, 8 minutes into the president's speech announcing it, registered the domain name. And so
is it a public entity, the Board of Peace, or is it a private entity?
At this point, I'm not sure if it's formed or not. We acted as a custodian so that they could have the mark.
How did you come to act as a custodian for that trademark?
Under 35 U.S.C. Section 3, it's my responsibility to advise the President through the Secretary of Commerce on matters of national security and all matters of intellectual property.
So the Board of Peace is a public entity? It's a governmental organization, even though Congress has not created it? Is that right?
Sir, I don't know the status of whether it's an entity formed or not.
Okay, well, how did you get involved in it? Did the president call you about the cyber squatting incident?
No, the president did not call me. It came up through several organizations about the cyber squatting, and the action needed to be taken to
When you
address the
talked
harm.
about the cyber squatting, you noted that there were lots of other organizations that were already using some variation of peace organization, peace committee, world peace, and so on, right? There are dozens of them. I mean, I found them this morning just on the way in.
Well, again, a reference was made to Shakedown. This was registered, this particular boardofpeace.org, and without that, you don't have the
You
ability.
registered that?
No.
Oh, who
A cyber squatter did. I mean, 8 minutes into the
But
president's
you don't
speech.
have to talk about a cyber squatter. There are dozens of other groups that have peace in their name, right? Well, look, where does your legal authority come from to file trademark applications on behalf of this Board of Peace, whether it's a public or private group?
It comes from the combination of 35 U.S.C. 3 and 35 U.S.C. 2 under the Lanham Act and in your opening statement.
Well, wait, do you usually act as a custodian for the intellectual property rights of other entities, or is this just for President Trump?
This was to protect the name Board of Peace as the entity gets booted up, to act as a custodian in a very narrow capacity with a bona fide intent to use the name, and then it's a intent to use application.
Who has the bona fide intent to use it?
The USPTO.
The USPTO, what are you going to do with it?
In the very limited services that we define there, which is fraud, prevention, misuse.
But is that a service you offer to all American citizens? In other words, if I'm thinking about maybe creating a group one day and we might want to have a trademark and I'm afraid somebody else has a competing trademark, you will go ahead and file the application for me?
My responsibilities are, again, under 35 USC Section 3 to advise the president on matters of national security.
So this is a matter of national security? Okay, let me ask you this. You've emphasized today, and rightfully so, the importance of people who are applying for patents or trademarks to pay a fee, because yours is a fee-paid office. How much does it cost for someone to seek a trademark? When you applied for that trademark for the Board of Peace, how much does that cost?
It's not an expensive fee, depending upon...
The website says $350, is that right?
Generally, yes.
It's not expensive. Okay. And my one of the able lawyers on my staff just passed me this. You filed a petition on January 21st, 26 to waive that fee for the Board of Peace. Then you granted that petition the very next day, which underscores the bizarre conflict of interest you're in, now acting both as a representative of the Board of Peace and also the trademark office that's going to pass upon the petition. But why did you seek a waiver for the $350 for the Board of Peace, and why did you grant it?
The waiver was sought under the particulars of the intent to use application as the custodial filer, and I did not grant my own application.
Well, your signature, as I'm reading it, you filed this on the 21st, and then you approved it on the 22nd.
Well, I would like to see the document to which you're referring.
Okay,
but,
we will get you those documents. Are you saying you would not have approved it had you seen it?
I'm saying I don't recall this particular situation.
Okay,
but I do believe it's in
your
my authority.
Signature, okay, it was approved by Dan Vovanisi, but your signature is on the petition. And I guess,
yes.
Why did you request that waiver of the $350 payment for the Board of Peace?
Again, given that this is going to be an international organization, given the situation with the intent to use and the bona fide limited scope that we had, I made that petition just as I signed the application, and it was granted
Okay, and then
by someone
finally,
else.
you know that the Lanham Act forbids anyone from submitting an application unless they're the owner of the mark or the legal representative of the mark. So were you representing yourself as the owner of the mark or the legal representative when you filed the petition?
No, we are very clear. It's on a custodial basis. We are not the owner. It will be transferred to the entity once it's formed.
Okay, well, you're listed as the owner on the petition, both for the waiver and also the application. So, I mean, that's the way the Lanham Act works. In other words, if I'm asking for your advice, could I get another company to apply for a trademark for me? What's the answer to that?
If you're the President of the United States, yes.
The President of the United States could have somebody else. The President of the United States has tons of trademarks. So you're saying that he doesn't have to submit himself? Where does it say in the Lanham Act that the President of the United States is exempt from the general rule that you cannot have a third party seeking an application on your behalf?
I'm, again, directing you back to USC 35 USC Section 3, where it's the Undersecretary of Commerce and Director of the Patent Office shall advise the President on national and certain international intellectual property policy issues.
Those are matters of public policy. They're not questions of representing the president before the trademark office, which obviously creates a stark conflict of interest.
The gentleman's time has expired, but you may answer.
Sir, I was not representing the President of the United States in this regard. I was representing filing an application to address the cyber squatting issue under my authority under 35 USC.
I appreciate it. Thank you. I yield back, Mr. Chairman.
Thank the gentleman.
Here's the simple problem with everything you just watched. John Squires could not answer a single basic question. Not one. Raskin asked him whether the Board of Peace was public or private. Squires said he didn't know. Raskin asked who told him to file the trademark. Squires couldn't say. Raskin asked under what legal authority he acted. Squires kept pointing to a statute about advising the president on intellectual property policy, a statute that has nothing to do with filing trademarks on behalf of third-party organizations. And when Raskin asked him whether he would do this for any regular American citizen thinking about starting a group someday, Squires had no answer at all, because the answer is obvious. He wouldn't. This was a favor dressed up in legal language and wrapped in national security jargon to make it look routine. It was not routine, it was unprecedented, but it's actually worse than that, because the clip only shows you the evasion. It doesn't show you what's underneath. Let's start with the Board of Peace itself. This is an international body that Trump announced during his plan to end the war in Gaza. He launched it formally at Davos in January 2026 and called it, in his own words, the greatest and most prestigious board ever assembled at any time, any place. The structure works like this. Countries can join for a 3-year term with no financial commitment, or they can pay $1 billion for permanent membership. PBS reported that a $1 billion contribution secures permanent membership on the Trump-led board, instead of a 3-year appointment. So far, countries including Saudi Arabia, the UAE, Qatar, Kazakhstan, Azerbaijan, Morocco, Bahrain, Kuwait, and Uzbekistan have joined. Several of those governments have pledged roughly $7 billion combined. Trump then announced an additional $10 billion from the United States, money Congress never appropriated. NBC reported that at the Board of Peace's inaugural meeting in Washington, board members had committed $7 billion for reconstruction in Gaza, alongside a $10 billion commitment from the U.S. Now here's where the trademark issue stops being a technical question and starts being a constitutional one. Trump declared himself chairman for life. The board's charter gives the chairman, meaning Trump, absolute power over budgets, financial accounts, and disbursements. The Carnegie Endowment for International Peace documented that all executive board decisions are subject to the chairman's direction and control, and that Trump will retain absolute power over Board of Peace spending. There are no auditing mechanisms, no conflict of interest rules, no oversight structure, and negotiations are reportedly underway with J.P. Morgan Chase to set up a private account for the Board of Peace accessible by the chairman and/or his designates. That's not a peace organization. That's a private fund with a presidential seal on it. And that's what makes the trademark move so important. Because here is how trademark law actually works, and why Squires was squirming. Under the Lanham Act, the federal statute that governs trademarks, only 2 kinds of people can file a trademark application. You either have to be the owner of the mark or the legal representative of the owner. That's it. Section 1051 of Title 15 is explicit. Raskin said it plainly at the hearing. The Lanham Act forbids anyone from submitting an application unless they're the owner of the mark or the legal representative of the mark. Squires admitted on camera that the USPTO is not the owner. He said the mark would be transferred to the entity once it's formed, but the entity hasn't been formed. So who does the USPTO represent? Squires had no answer. He just kept saying the word custodial. But custodial filer is not a legal category under the Lanham Act. It doesn't exist in the statute. Raskin's letter to Squires laid this out explicitly. Section 1051A of Title 15, known as the Lanham Act, specifies that only the owner of a trademark used in commerce may request registration of its trademark. Squires invented a role for himself that the law does not recognize, and he did it to protect the branding of a presidential project that hasn't even been legally incorporated. Now layer on the conflict of interest. This is the part most people miss. The USPTO isn't just the office that files trademarks, it's the office that decides trademark disputes. If anyone, say the World Peace Table, or Global Peace Foundation, or Greenpeace, wants to challenge this trademark, who adjudicates that challenge? The USPTO. Meaning Squires' own agency would be acting as both the applicant and the judge. That is an impossible conflict. Raskin put it perfectly in his opening statement. You're both the owner and the judge of any rights you have as an owner against anyone who wants to identify their organization with peace. That's not a gray area. That is a structural breakdown of neutrality inside a federal agency. And then there's the fee waiver. This part deserves its own spotlight. The filing fee for a trademark is about $350. Not expensive. But Squires petitioned to waive it, and his own office approved the waiver the next day. Raskin read the documents aloud in the hearing. Filed January 21st, approved January 22nd. When Raskin asked Squires about it, Squires said he didn't recall the situation. He then said a staff member named Dan Rovenisi actually approved it, not him. But his signature was on the petition. So at minimum, the director of the patent office personally signed a request to waive fees for an organization that doesn't legally exist, filed under a legal theory the Lanham Act doesn't support, and his own agency rubber-stamped it in less than 24 hours. That's not cyber-squatting prevention. That's institutional capture. Here's the trap that Raskin set that Squires walked right into. There are only 2 possible explanations for what the Board of Peace is. Either it's a governmental entity or it's a private commercial entity. If it's governmental, then under Section 1052B of the Lanham Act, its insignia cannot be trademarked at all. The statute specifically forbids the registration of any insignia of the United States or of any state or municipality or of any foreign nation. But if it's a commercial entity, which filing a trademark essentially admits, then Trump is running a private, for-profit operation funded by billions from foreign governments while serving as president. Raskin made this point devastatingly at the hearing. By filing for a trademark, you're admitting that the Board of Peace is not really a governmental entity at all. It is a purveyor of influence, operating for profit. Either door Squires opens destroys his own argument. That's not a hearing question. That's a legal checkmate. And this wasn't just Democrats making noise. Reuters reported that the hearing featured bipartisan grilling of Squires. Republican Congressman Darrell Issa, who chairs the Intellectual Property Subcommittee, raised his own concerns, not about the Board of Peace trademark specifically, but about Commerce Secretary Howard Lutnick's potential conflicts of interest affecting the USPTO's Patent Trial and Appeal Board. Issa said publicly that Lutnick may not have eliminated all of his holdings, and therefore there could genuinely be a conflict. When a Republican chairman is talking about subpoenaing a Trump cabinet member over conflicts of interest at the same hearing where a Democrat is exposing a sham trademark filing, the problem isn't partisan, the problem is institutional rot. That wasn't just evasive testimony, it was obedience disguised as procedure. What you watched Squires do in that hearing was not confusion, it was compliance. He couldn't tell Raskin whether the Board of Peace was public or private, because the answer to that question is legally fatal either way. He couldn't name who told him to file the trademarks, because naming the White House would confirm political direction of an independent regulatory process. He kept using the word custodial, because it's the only word that sounds neutral without having any legal meaning in this context. Every non-answer was strategic, every dodge was protection, not of the office, but of the president. This is not about a $350 filing fee. This is about whether the United States Patent and Trademark Office, a fee-funded, congressionally established, traditionally nonpartisan federal agency, has been converted into a brand management service for a presidential slush fund. A fund that collects billions from foreign governments, a fund with no congressional authorization, a fund with no auditing, a fund controlled entirely by one man who happens to also be the president. And when that fund needed legal cover to protect its brand, the head of the trademark office personally signed the paperwork, waived his own fee, and couldn't even explain under oath who told him to do it. This is what corruption looks like when it's wearing a suit. It doesn't come with a smoking gun, it comes with a filing number, a rubber-stamped fee waiver, and a man at a hearing saying, "I don't recall," over and over, while a congressman reads his own signature back to him. So when someone tells you the Board of Peace is just about rebuilding Gaza, here's the truth. It's a $17 billion fund with no oversight, no auditing, no congressional authorization, controlled entirely by a president who named himself chairman for life. And when it came time to protect that brand, the head of America's trademark office did it personally, waived his own fee, broke the Lanham Act's ownership rules, and then couldn't explain any of it under oath. That's not peace. That's a scheme. And Jamie Raskin just put the receipts on the record.